My name is Raiden Barlow, and here is my case brief for Groff v. Dejoy. The plaintiff of this case is Gerald Groff. Gerald is a Christian USPS worker, and because of his religious values, he believed he shouldn't work on Sundays because they are a time of rest. Because of this, he made several requests for accommodations, but many of them were denied, and eventually he was forced to quit because of this. He took this issue all the way to the Third District Court of Appeals, but that case he lost. Groff claimed that many of the punishments he faced violated the Civil Rights Act. Specifically, the Civil Rights Act Title VII says that if a accommodation does not cause undue hardship on the conduct of the business, then a business should reasonably accommodate it. Groff claimed that they could have accommodated him. The court held in Groff's favor. They also believed that USPS was more than capable of accommodating him. But that wasn't the only thing that they determined from this case. They also determined that the meaning of Title VII of the Civil Rights Act was needed to be changed just slightly. Specifically, they changed undue hardship to substantial increased costs, meaning religious accommodations would be far easier in the future. The court claimed that employers needed to show a much greater burden of proof before they can deny religious accommodations. However, that was something Dejoy was unable to prove. There weren't any dissenting opinions about the case, and it was unanimously in favor of Groff. The case was very important to those that needed similar religious accommodations in different work environments. It raised the bar on what an employer considered to be an unreasonable accommodation, which of course made greater freedoms for those in different religions. What it also did was make it a case-by-case basis thing. Basically, each case was seen differently and not as the exact same rules and standards.